Hello, and thank you for joining us today on the Ask Andrew Show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal here at the Greater Toronto family law firm, Feldstein Family Law Group. And today I will be joined by our special guest, Brodie Mulholland from Mulholland Law Offices. Mulholland Law Offices provides a comprehensive spectrum of legal services in areas including estate planning, business, trust, and tax law. He is here to speak with us today about the intersection of family law and estate planning. So without further ado, Brodie, thank you for joining us on the show today.
Thanks for having me.
So I know sometimes some lawyers will say I find things more interesting than other people do. And I actually find the topic of today's show to be very interesting about estate planning and trying to learn from there. But what are the right ways from a family law perspective to do things and how you propose them for your clients? And I know some family law lawyers find this stuff to just be awful, and I think it's interesting and fascinating. So I wanted to start off with a question. I think it's a pretty generic question. Is you probably have wealthy clients who come to your office and they say to you, Brodie, my child is getting married, and this is my first child getting married, and I want to start thinking about how to transfer wealth to my children in the most efficient tax way. And then that probably raises some alarm bells for you. And I would like to hear what you would say to that type of client.
Well, it's a really common question. As you can imagine, I'm sure that the same happens for you with people who come in to see you. And it really involves the intersection of estate planning and family law. And, one question that I often get asked is, how often does family law come up? And I would say almost always. So, one of the things you look at, for example, you'll have clients who want to assist a child with getting a home in the GTA. So many parents will come in and say, look, my kids can't afford to get into the market and I want to help them. So they want to give them money. And I say, wait a minute here. If you give them money, you can lose that half of that money to an ex-spouse if the first marriage fails, for example. So we have to look at ways to try to protect that. And of course, what I say is not always heeded, but it really makes for some very interesting conversations because most people are not at all familiar with what can happen in some of the family law considerations when it comes to estate planning.
So when I get asked that kind of question as a family law lawyer, what I usually will say to people, and I think it's the same answer that you have, which is get a marriage contract.
Yes.
The interesting thing is the dynamic of when I'll hear about someone talking about a marriage contract and I'll get the phone call when someone is saying their spouse, or not their spouse, but their parent tells them they have to do it. Sometimes reluctantly calling, they're upset about it. Now we don't do marriage contracts and we send them elsewhere, but we do get calls for it. And I know the general tenor of it is people are really nervous about it. And I think a lot of those calls comes because of the advice that you happen to tell to certain people. So what I think people would like to hear is when you tell someone, how do you tell it to them? What do you give them advice on how to communicate the idea of a marriage contract? Because it's really a sensitive topic.
It's a very sensitive topic. And often in my view, a marriage contract is the best protection for a lot of the things that we're going to talk about here today. But they're also fraught with some real concerns. And I'll maybe let you address some of your concerns and why your firm doesn't do these and passes them off. But, some of the issues to try to make it a little bit more palatable, I certainly had clients that, where I've later have one right now that they're 10 years into their marriage, wealthy family that the son came from, and basically carried through with the request of the parents to actually have a marriage contract. One of the things that I try to encourage my clients, particularly wealthy clients, where they feel that it's important to try to protect against what might happen from someone coming in and marrying and then there being a divorce, is I try to suggest to the clients that they lay the groundwork early. Because the absolute worst thing that can happen is on the steps of the church at the time of the marriage, oh, gee, you've got to sign this contract. That's not a good way to start a marriage. So move back a little bit, start early. If it's really something that the family's going to insist on, then talk about it so that the children know that this is one of the things that is expected. Still doesn't make it easy.
Well, I want to start with when you said don't ask for it on the doorsteps of the church. The reality of that is that's going to be a ground to set aside the agreement later on, because someone is going to say, I was under duress when I signed it. The 500 invitations went out. Everybody had been hired. This massive wedding had been planned. Can you imagine the shame it would bring on me to cancel my wedding a week before when I was presented with the contract? So I signed it. And that can be a successful argument.
It's interesting because there are certainly cases where it has been. So yeah, no, absolutely. I mean, it might be a different definition than you and I might normally think of as duress, but it's absolutely something that the courts have taken into account, and then it does make a lot of sense. So yeah, you do need to step back, and but no matter how much you plan for it, it's never going to be an easy discussion. And be interesting to be a fly on the wall when the family was having the family dinner, and Junior was being told that no, you've got to make sure you have a marriage contract, or you're not going to receive your inheritance. Not an easy conversation.
Well, one of the ways I also look at it is people frequently will say, well, what's the difference? It's an inheritance. And if it's an inheritance, it doesn't count. I get to keep it. Yeah. And the thing is, that's a general statement. And what people don't realize is the details of an inheritance. And I'm going to walk you through a few points that people need to do in order to exclude it properly.
Good.
First of all, if you use that inheritance towards a home that is a matrimonial home, and you can have more than one matrimonial home. So if you buy a cottage, the same thing can apply.
Exactly.
You lose the exclusion. You're going to share it. And if you want to keep that exclusion, what you really need to do is you have to trace where the money came from all the way to the date of separation. Now, some might say, well, that's easy. And it may be easy if the parent passed away in 2017 and you separate in 2019, and you can show the money hit your bank account in 2017 and you show it sitting there from 29 all the way up to 2019. But I've had clients come in who got an inheritance in 2002. And then they have to trace it to 2019. Now, that's a whole different game. So that's why a contract can be important, because a contract can deal with a different regime than what the statute provides for.
Right.
And if you really take a step back and you scratch your head and you say, for most people, when they get an inheritance, the most logical place for it to go is into the home. That's the most logical place. You're going to pay off your mortgage. You're going to buy a bigger home. You're going to do some renovations. These are the places people would usually want to spend money. But are you going to say to your spouse after 15, 20 years of marriage and you get $1 million inheritance, sorry, honey, we have an $800,000 mortgage, but I can't pay that mortgage off because if I do, it means I'm sharing my inheritance with you. You might as well go to the divorce lawyer right away, because that's where you're heading. So that's why some careful planning can be very smart to say how you're going to deal with it. One way some firms will deal with it is say, I don't need to trace it anymore. Whatever that inheritance was, if I got an $800,000 inheritance, let's treat it like I had an asset on the date of marriage. And whatever it becomes, I always get credit for the $800,000. That makes life simpler, and sometimes it's easier for people to understand. But why I'm walking through this is to say, don't just assume that the family law protects you, because odds are it probably doesn't.
Right. Yeah. So the home and the cottage are, generally for most people, those are the biggest assets. So most likely that's going to be the place that inheritance will go. So you really have to be careful. One of the things that I suggest to clients, I certainly agree. I think a marriage contract is the best way to protect against that. But as we said earlier, it's fraught with various concerns. But a simpler way is perhaps to make a loan. So instead of actually gifting funds, you make a loan, you document the loan. If it's a significant amount, even better, take a second mortgage after the bank financing has gone in. But certainly document a loan. Then that can take it out of the category of being an inheritance and a gift. And again, making sure it's documented properly, but then it becomes a debt obligation. Some of the things, the objections people might have to that is, well, gee, a loan means I have to charge interest. Well, technically you don't. And in Ontario, and we're really speaking from an Ontario law perspective here, you get into questions, concerns about, well, gee, after 2 years, doesn't that loan expire? Well, no, the law was changed a few years ago to basically say that with a loan like this, that this limitation period starts from the date of demand. So you don't have to have interest payments. You can have it going on for an extended period of time. And so it fits fairly well in the typical family law context where, gee, I want to give, Junior this money. Okay, I'll make it a loan to make sure I protect it. The other concern that people raise sometimes is that, gee, I really do want to give it to them. And that can be dealt with fairly simply by, at some point in time, the parent can forgive the loan. Often that's when I'm drafting a will. That'll be one of the things that we provide, is that the loan is forgiven. And then the question becomes as well, is that part of the inheritance or not? Typically it will be. So gives you a fair amount of flexibility. It's not overly complicated, and it's certainly less complicated than having a marriage contract.
Except in a family law context, we can go to court and there's a body of case law that talks about discounting the value of that loan based on the likelihood of repayment. So a court can look at it and say, mom and dad lent one of the children $500,000 or both of the children. And one of the things you look at is, were the loan documentations done? And if they were, that's a tick mark towards it being a valid loan. But if no repayment of money for 5 years on that loan, well, that's going to be a problem, because you walk like a duck, quack like a duck, it's a duck. And someone will say that was really a gift. And a smart lawyer will even ask to see mom and dad's will, and showing that that was never planned to be paid back. So it really was just a gift disguised as a loan.
Always a risk. Yeah.
So what I tell my clients, the smartest way, if you're going to do that, is actually make loan payments.
Yeah.
Even if you don't want to create an interest to it, make loan payments. And if you really want to be smart, make sure the loan payments come out of a joint account.
Yeah.
So that the former spouse sees it, because you really want both spouses to sign the note.
Mm-hmm.
You want both spouses to be paying towards it. And the best thing you can do, if you're really, really smart, is you go to your wife and you say to your wife, could you mind writing those checks out of the joint account to pay my parents for their loan? Because it really is difficult to say it was really a gift when you're the one who was writing the loan checks back.
Exactly. Yeah.
And believe it or not, I had one client, the wife was contesting the loan, and he came in with the ledger that was prepared by the wife, showing the balances and the fact that she was the one that wrote the check for 5 years. So to me, that was the gold standard, that it wasn't a gift.
Yeah, absolutely.
And it's a matter of how close you can get back to that gold standard, because even if you're paying something back, it certainly looks like it's a loan over a gift. So you got to be thoughtful about that. And the other problem you can run into is what you're telling third parties. Because if you're going and you're getting financing to buy the house, and you're borrowing money from your parents, the bank may turn around and say, where are you getting these deposit funds from? And if you say, it's a gift from my parents, the bank may very well give you a document from your parents to sign that it was a gift.
Yes.
And then, some lawyer like me, if I'm acting for the other spouse, is going to go get that gift document and start waving it around saying, it wasn't a loan, it was a gift. That's what you told the bank.
Yeah. And that is always a concern. I guess the reality is that generally banks don't look at that after they've advanced. So the safer route is to do it later so that everything is accurate and above board. But yeah, absolutely, that's none of these things. It's not a panacea. It's always there's always shades of gray.
And the other place to go too is if you're mom and dad and you're sitting there with your financial advisor, and your financial advisor says to you, "Can you do the statement of assets and liabilities for me?" Make sure you include that loan receivable as an asset, because 5 years later, when there's a dispute and you've been doing that every year, that's something lawyers will look at. And if you're the one who owes the money and you're filling out statements of assets and liabilities, put the debt down. So it's really important that if you want it to be a loan, treat it a loan the same way as it was with a financial institution, disclosing it to any third party that you would have to.
Mm-hmm.
And to me, that really is critical. And like we said before, the most common place that you're going to deal with these kind of issues is a loan or gift, probably around the time of buying a piece of real estate.
Mm-hmm.
Because our real estate market here is so expensive, most kids can't afford it.
No, exactly.
Now, what do you do? I'm going to change it a little bit because you do estate planning and you do wills as well. So what do you do when you have the parent who comes into your office, usually both parents, and they say, well, I have a nice net worth. I want to plan my will. I want to make sure all my children get my estate. But God help me if that daughter-in-law of mine is going to be able to get a penny on my money. If that's the case, I don't want my son getting anything.
Right.
Another way to be gender neutral as well. So what do you say to that person? I don't want my son-in-law to get a penny of my money. He's no good for nothing.
Yeah. Well, I wish I had $1 for every time a client asked me that question. So again, there are various things. It's like what we've talked about already. There's nothing that's going to be absolutely certain and sure about protecting that. So some of the things that you can do, we've talked about some of them already, is if you have a marriage contract where it's clear that I've forgotten which gender we're talking about, whether it was him or her, but let's say that spouse, the spouse who's entering coming into the wealthy family. If that spouse signs an agreement, gets proper advice on that, then there's a good chance that if they acknowledge that they're not entitled to receive a portion of the inheritance, the gift, then that should be enforceable. So that's definitely one way. What might be a more common way to do that is when a parent is leaving an estate to a child, instead of actually leaving the interest outright to the child, putting it into a trust for the child, at least for a period of time, until, often the parents will say, well, gee, by the time the child's 35 or 40, then they'll hopefully be in a stable relationship and we won't have the same concerns. So let's defer them getting control of that inheritance by having a trust imposed. And then we've got some greater certainty. And I'm sure that, Andrew, the next thing you're going to say is talk about all these cases where family courts have basically looked at these and attacked these sorts of trusts. And that's certainly a concern. But generally speaking, if the trust is set up and the asset is treated as not being a family asset or an asset of the child, then there's a good argument that it's not an asset subject to division in the event of a marriage breakdown. But having a trust creates other problems. You've got to have a trustee. It needs to be a third party. Somebody's got to pay the trustee. It means that the child, up until whatever the magic age is, 35, 40, they can't control that inheritance. They've got to go to a third party to do what they want with it. Not ideal. Other issues that, maybe we can talk about this a little bit later is people often forget how they own property, and that a trust can only attach to property that you own at the date of death, setting up the trust. So, again, not, there can be concerns.
Okay, well, I have a question that I'm going to come to in a few minutes, but I want to discuss the issue we were talking about with the trust before I deal with that question. And when you talk about the trust creating issues, and I understand it creates issues because most people, if they're the beneficiary and they're 35, 40 years old, they may be in their starter home and want to move up or want to pay down the mortgage, and they're going to want access to that money. But here's the interesting tidbit. The average age of a male when they are separating is 44, and I believe the woman is either 39 or 40.
Right.
So it creates a problem in terms of if you want to protect them, and the age that you're talking about protecting them, really, if you want to be safe, is probably closer to 50.
Right.
But the problem with that is most people, that isn't the time when they really, really need the money, which is when they're younger and they have kids and want to put the kids into programs and activities. Or if they get it when they're 50, that may be going to the grandchildren's university education or college education. Maybe you're perfectly fine with that.
Mm-hmm.
But it creates some interesting dynamics and, like you said, additional fees. But it really boils down to a choice that I frequently will say to people. You have to decide what is your greatest threat. Is your greatest threat the way they would put it in my office, that no good for nothing son-in-law or daughter-in-law? Or is the greater threat limiting the child to be able to help them when they may really need the help with that money? And that parent is going to have to choose their poison of which one is worse. I don't know if you agree with that kind of viewpoint.
I think that's what it always comes down to, because there's no absolute right answer either way, and there's no absolute for certain way of accomplishing what they hope to accomplish. And then you layer in what we talked about earlier, and just the family considerations and the acrimony that it can create in a family. It's, for me, one of the reasons this is such an interesting, fascinating area to work in. There's so many different complexities that are involved, and certainly not just legal ones.
No, there's a lot of emotional ones to a marriage contract and how you plan around it if you're not going to do a marriage contract. I mean, one simple way, and it doesn't cost you anything, is if you're coming into a marriage with assets, is to go keep all your statements in a safe place. So you save them in the cloud, you put the hard copies in a safety deposit box that your spouse doesn't have access to. And then when you separate, you can prove what you had on the date of marriage. I know my ex-wife wasn't thrilled when I was able to prove everything I had on the date of marriage. I didn't ask for a marriage contract, should have, having done this for a living. But at the very least, I could prove what I had on the date of marriage. And if you have something significant, that's something to think about, as well as not owning a house on the date of marriage that you're going to live in. I just want to take a break to move over to the question, which is on a completely different topic, where the person says, I left my ex in March. I am 2 hours away with an 11-month-old child living with family. Only now is he trying to file a motion for me to go back. I left because of abuse. Well, if he's filing a motion, then you're going to have to respond to that motion, and you're going to need to deal with it on the basis of also your own motion that's going to permit the move. But note, if he's filing it now, there's a requirement under the family law rules if there has not been a case conference to establish urgency. And if he's waited 11 months, it's going to be difficult for him or her to establish urgency. So you got to focus on that. And the first thing, if they're bringing an emergency motion, you should write to them and say, have they canvassed case conference dates with the court to see whether or not they've tried to get an emergency case conference date first. If they haven't done that, that will be very problematic to their case. So I hope that helps the viewer. If they have more questions, they should call our office and ask for a free consultation. I apologize for going a complete 360 when we're talking about one type of topic, Brodie, and then moving into parenting. Yeah. But the scenario that we just spoke about, I find to be a very common scenario, which is that concern in estate planning. And you really do need to think about it. And this is something I've said to other estate lawyers, is that when you're drafting that will, you need to assume that the former spouse may try to get a hold of that will, even before anything happens, because that may create issues in the litigation that may help. Like I said earlier, was it a gift or a loan? Mm-hmm. Because that's going to be evidence towards that. It may be evidence to how some people consider assets. And even a probated will, because the probated will may list all the assets, and you may have said that some assets were your parents and not yours. And in order, when you're the trustee, you're trying to avoid to pay the probate fees. You may say, oh, well, that asset wasn't my mother's. It was always mine.
Right.
Well, somebody like me is going to go pull the probate file to see what assets were listed and do they line up with the story that you're telling me in the divorce case. So you really got to be mindful of being consistent. My next question is, a parent wants to, or someone is in a second marriage and they have children from a previous marriage.
Right.
Now they come to your office and they want to do some estate planning, and they say, I love my new spouse very much and I want to leave something for my new spouse, but I also love my children. And I've discharged all my obligations in the separation agreement for insurance. So the kids are old enough now, but how do I balance these two competing interests with one another?
Short answer is not easily. One of the things that we look at is, sound like a bit of a broken record, and that is look at having some sort of a marriage contract that will deal with it. Most commonly, what I will see and what we'll do is, and this is somewhat old school, is you'll have what's called a spousal trust in the will that will provide that the spouse, the second spouse, will be looked after, will receive all of the income from the inheritance, and then give you set up a third-party trustee with the basically the decision-making power as to what that spouse would be entitled to receive. And so that if in order to maintain the spouse's lifestyle, you have to go beyond just the income, you give the trustee the discretion to do that. So you set up, as they say, what I call a spousal trust. And then when that spouse passes away, everything will then go to the children. So not an ideal solution, but it is a fairly common one, and one that's been around for many, many years. What are some of the problems with that? Well, often the second spouse is much younger, and sometimes the same age as the children. So it may mean that the children don't get the benefit of any of that inheritance for most of their lifetime. That's not generally what a parent wants to have happen. So it's always sort of trying to come up with the right solution for the right situation. If going into the marriage, the second marriage, there's the marriage contract, great. If there isn't, well, I guess good luck trying to get one after the fact. But if you can do that, then at least that will perhaps be fairer than setting up the spousal trust, as I've suggested.
Or what some people do is they just allocate a certain amount to the new spouse and a certain amount to the children, or use life insurance vehicles to do that, and let the cards fall where they may, and hope that the new spouse will be kind enough to give whatever they have left over back to your kids and not their kids. And whether you think that will actually happen or not, who knows? And then you also have the situation of, will there be enough left over to go around for everybody? So it makes for what is a very challenging dynamic for the person who has the assets. And it really boils down to how much trust you have in your new spouse and how much you want to give to your kids, and whether you're being naive or not naive.
And something that we haven't mentioned is the prospect of an equalization claim made by the spouse when someone dies. So I don't know that we've got time to get into that, but very important planning consideration.
We don't, and that's where a marriage contract is helpful for a second marriage.
Absolutely.
Very quickly before we sign off, I saw there's another question just came in that's off topic again, similar to the first one, is I relocated 5 months ago with my child, and my ex is trying to prevent me from relocating and wants visitation rights. What are my rights? Well, certainly the ex is going to have rights to see the child. Maximum contact principle under the Divorce Act says both spouses should see the children. And again, it's basically the same answer as the last one. They've waited 5 months, and you're going to have to go to court, and you're going to have a dispute that a judge may have to make that determination. I had to run through that very quickly because we are at the end of our time for today's show. So Brodie, I wanted to thank you for coming on the show today. It was a pleasure having you. For anyone interested in learning more about Brodie Mulholland and his practice, you can visit www.mulhollandlawoffices.com. And the next Ask Andrew show is on a date to be determined in September, and we will notify our mailing list and we will be promoting it on Facebook as we always do. If you have any requests or ideas for future shows, please email them to us at info@feldsteinfamilylaw.com, and thank you for watching.